Ambedkar, which he expressed at various platforms. And one such platform is that Independent Labour Party program of 1936. What he quote, and I would like to quote here, what he said, which I would like to quote here, and I quote, "We must make our political democracy a social democracy as well. Political democracy cannot last unless there lies at the base of it social democracy." What does social democracy mean? It means a way of life which recognizes liberty, equality, and fraternity as the principles of life. Unquote. So what he basically he and you can see this in the directive principles of state policies of the Constitution of India. You will find that there whatever directives are there, they are based on this philosophy of his, because his political democracy is also social democracy and economic democracy. Now, when he says social democracy, in that social democracy, he recognizes three principles which he has stated, that is liberty, equality, and fraternity. Now, what he said further in that is that he said that these three principles of liberty, equality, and fraternity, they should not be treated separately. He meant to say that they are a trinity, and they are a union in trinity. So you cannot separate equality, liberty, and fraternity as different aspects. They are to be correlated. So according to him, this liberty cannot be divorced from equality cannot be divorced from liberty, and fraternity cannot be divorced from equality or liberty. So he put more emphasis, we can see that, on these three principles of fraternity, equality, and liberty. So when he was speaking in this program, he further what he said is that, okay, without equality, liberty would produce the supremacy of few over many, and equality without liberty would kill individual initiative. So that's why separating this will not achieve the social democracy which he has envisaged for the nation, and for which he has provided various provisions in the Indian Constitution. So, according to him, without fraternity, liberty, and equality, they could not become a natural course of things. In one of his speeches in the Constituent Assembly in the year 1949, when he said that his ideal uh, for a society would be a society which is based on these three principles of liberty, equality, and fraternity. And when we read Annihilation of Caste, in that his thought about liberty we can understand, and therein certain extracts from that Annihilation of Caste, which I would like to quote here, and I quote Dr. Babasaheb Ambedkar in his Annihilation of Caste. My social philosophy may be said to be enshrined in three words: liberty, equality, and fraternity. Let no one, however, say that I have borrowed my philosophy from the French Revolution. I have not. My philosophy has roots in religion and not in political science. Unquote. So here again he emphasized his social philosophy having the roots in these three principles. And here he one thing that he pointed out, that this is not something, these principles he has not taken from French Revolution. But from where he has taken, he said that in his philosophy, these principles he has taken from the teachings of his master, that is Gautam Buddha. So, and according to him, because he's a well-read person, he has read Buddha and then he has understood it very well, and that's why he was so much impressed by the teachings of Buddha, that he has adopted this most of the teachings of Buddha's, and that too you can find it in these three principles of liberty, equality, and fraternity, uh, which he has accepted as his social philosophy. So, what he said further in Annihilation of Caste, and I quote, in the philosophy of Buddha, liberty and equality had a place, but he added that unlimited liberty destroyed equality and absolute equality left no room for liberty. And in Buddha's philosophy, law had a place only as a safeguard against the breaches of liberty or equality, but he did not believe that law can be a guarantee for breaches of liberty or equality. Unquote. And again, at the he when he stated this, he further added that for Buddha, fraternity is the only real safeguard against denial of liberty and equality. If you'll see the preamble of the Indian Constitution, these three principles they are provided in the preamble, which is the actually it states the objectives of the because preamble it states the objectives of the constitution. So the basically the constitution is based on uh, in the preamble we can see that it is based on this social philosophy of Dr. Baba Sahib Ambedkar, and which is enshrined in these three principles of liberty, equality, and fraternity. Again, when we see now going to John Stuart Mill, his work on liberty, and in that book also, if you see, you will find that John Stuart Mill he has suggested that a struggle always takes place between competing demands of authority and liberty. And what he claimed in that is that we cannot have latter without the former. So we cannot have liberty without there is a competing demand of authority. And then also Mill further claimed that the fullest liberty of expression is it is required to push our arguments to their logical limits. See, this is really very important to understand when he says that the fullest liberty of expression, why it is required, uh, that whatever arguments we have on any topic, we have to push our arguments to their logical limits rather than the limits of social embarrassment. So, because when we say that there are so many things like freedom of speech and expression, so uh, then there are various aspects of that, which there are sometimes there is a tolerance, there is intolerance, there is hate speech. So, whenever so he what he claimed is that there should be fullest liberty of expression. So he never says that something should be stopped. Uh, and such liberty of expression, according to him, is necessary for the dignity of a person. So, if liberty of expression is stifled, the price paid is a sort of intellectual pacification. And that sacrifices the entire moral courage of the humankind. A very big statement you can find in this work on liberty by John Stuart Mill. So what he wants that person should be free to express. There should not be restrictions on it because liberty, if it is differed, then that will be a kind of intellectual pacification. So, and then the human courage, moral courage will get affected if restrictions or obstructions are put on the this freedom of expression. He also, John Stuart Mill, he carefully read Democracy in America, that book which is by Alexis de Tocqueville, and Mill feared that after reading that book, on the basis of whatever he has understood from that, Mill feared that the will of the people would more often be the will of majority. And this could threaten liberty and individual self-development if the majority acted to oppress minority viewpoints and lifestyles. See, this is long back, like it is his observation where during his period and today also how far this observation fits. You can understand uh, looking into the situation which is prevailing relating to freedom of speech and expression. Uh, Further, what Mill say is that a democracy could easily become a tyranny of the majority. And to overcome this threat, what Mill proposed is, uh, and his proposition actually, the philosophers today they call it as a harm principle. And according to Mill, the only purpose for which power can be rightfully exercised over any member of civilized community against his will is to prevent harm to others. So I think these views of Dr. Babasaheb Ambedkar and John Stuart Mill, they are so relevant in today's scenario as well. And uh, when we uh, when we talk about Dr. Babasaheb Ambedkar's views on liberty, uh, we have to correlate it with the provisions in the Constitution, be it the preamble in which you will find all his three principles of social philosophy. They are included in it. The preamble speaks about justice, or along with justice, it speaks about equality, it speaks about liberty, and it speaks about fraternity, because these three principles were the teaching of his master, the Buddha. And according to Buddha, fraternity is required for exercising liberty and for promoting equality. Another, when we say of freedom, then the freedom is like liberty. This concept, this is a little bit when we talk of freedom. There are so many freedoms which we have seen that the Constitution provides a number of freedoms, which is a part of fundamental right. So freedom, what this freedom is, and the freedom, the meaning of that freedom is it is a power or right to act, to speak, or to think as one wants. So this freedom, when we talk about freedom of expression, we can correlate this freedom of expression. It is a human right, and it is a fundamental right under the Constitution of India, Article 19(1)(a), wherein that article it says that all the citizens of India they have the right to freedom of speech and expression. And the philosophy behind this it lies in the preamble of the Constitution, where there is we have seen that you must be knowing and you must have read that there is a solemn resolve to secure to all its citizens liberty of thought, expression, belief, faith, and worship. It is specifically provided in that. But in the Constitution, though there are this is freedom of expression and speech is a fundamental right. We know that there are reasonable restrictions also which are provided in that, and these reasonable restrictions they were also from time to time the restrictions were uh, added. More restrictions were added through amendment. So earlier, the restrictions on freedom of speech and expression, we know that it was for security of state, for decency and morality, for defamation and contempt of court. But then, as Professor Dr. Ramratan Dumar sir, he while addressing in the first session, he spoke of different cases, Ramesh Thapar case, Sakar newspaper case, and other cases relating to that. So those cases, because of those cases, certain changes like Ramesh Thapar case. After Ramesh Thapar case only, the amendment was made and more restrictions they were added to it. So friendly relations with state, public order, and incitement to an offense. These three more restrictions were added through First Amendment, which was made in the year 1951, and later on through 16th Amendment in the year 1963. Sovereignty and integrity of India, it was also added as one of the reasonable restrictions on freedom of speech and expression. So we don't have like an absolute, we can say this freedom of speech and expression. The freedom of it has to be, because there need to be a balance, because all philosophers, when they talk of certain concept, like when we speak of equality, when we speak of liberty and fraternity, as Dr. Babasaheb Ambedkar, he said that they cannot be divorced. So we have to balance, so that has to be balanced, and for balancing that also we need to have, nothing has to be absolute. So that's why the reasonable restrictions are provided uh, on this freedom of speech and expression. And this already Professor Romelo and Professor Dumarson, they have already discussed in detail about this freedom of speech and expression, uh, be it from the context of Mexican Constitution uh, or an Indian Constitution perspective. uh, I'll need no, I feel like I'll not go into much of it. But I would like to mention here that Universal Declaration of Human Rights, and that also, because some of the even the papers in that they also spoke about the international agreements and instruments wherein there is this right to freedom of expression. So it is also one of the human rights under Article 19 of UDHR, Universal Declaration of Human Rights. And recently, when we see, because the scenario now, see, a law keeps on changing, society keeps on changing, so law keeps on changing. The concepts also keeps on changing. So this freedom of speech and expression, earlier it was relating to speech, drawing, and it was all relating to materialistic media. So virtual media now, because we are into an age of internet, so cyberspace is there. So now because of this, so UN has declared this freedom of speech and expression in cyberspace as part of basic human rights. And this also, if you see recently, Supreme Court in Anuradha Bhasin's case, the Supreme Court has declared the right of freedom of speech and expression over the internet as fundamental right. This is the year 2020. This decision was given by the court. Supreme Court held that a complete shutdown of internet would have a negative effect on the circulation of free speech and expression. Now, with the advent of this internet, now people have changed the way they share information. Like earlier, we were having before COVID, we were having all the conferences, seminar, symposiums, and all the activities we were having in a physical mode form. But now things have changed. Now we are utilizing this internet, the virtual mode, for sharing information. So now this way of sharing information, it has changed because of this internet, and also this has got an impact on the consumption of intellectual property. This because of this new developments, now it has become easier for, also one of the, we can say that when we say that dissemination of information has become easy through internet, but then it has also become easier for people to misappropriate the protected material. Uh, we can this you can see through the sheer volume of piracy of intellectual property that has become difficult to regulate, and this expansion of private property right has come at the expense of free expression through the modern interpretation of copyright doctrine, and also due to the recent legislative implementation of certain international agreements like the TRIPS agreement, like the World Intellectual Property Organization's agreement on copyright and performers' rights and broadcasters' rights. So new things, because new changes are happening, New innovation is coming on, new technology is coming on, the mode of dissemination of information is changing, method of sharing of information is changing, and with it comes various issues, regulatory issues, which need to be addressed due to this in new inventions in this modern era. When we speak of freedom of speech and expression, we have to, when we talk of in context of IPR, intellectual property right, we have to correlate it with the copyright. And we know that this copyright law actually strikes to its own balance between author's right to property and public's right to information. But when we talk of copyright, by its very nature, the copyright it is an interference with the right to freedom of expression, because copyright gives the owner the they can suppress the forms of speech by seeking injunctions against those who want to express themselves by means of unauthorized uses of the copyrighted material. So these are the new things they are coming up with new issues. One very important this thing that has happened is the new this new era. It has helped mankind to come closer and to share information, but it has got its negative effect also. Like it has also become one of the fastest media to share information, and in sometimes it could be uh, uh, we can say rather than a bane sometime, because though it is a boon for certain things, but it has got its negative effects also, disadvantages also, because certain heat material they get propagated very fast, and such other things, negative things also. They are the effects of this internet, the new technology. Now, another concept, like when we talk of freedom of speech and expression, there is also some things there. The concept that is hate speech. Hate speech, what is it? It basically they incite violence, and they undermine the social cohesion and tolerance. And the scale of this hate speech and its impact, they are nowadays amplified by these new technologies of communication, like this Twitter, Facebook, WhatsApp, all these new technologies. So because they reach to the many people in a fastest way. So this uh, so now the question is about how to regulate certain things which are kind of like hate speech and certain other materials which affect the rights of a few or marginalized people, which incite violence, and which disturbs the social cohesion of the society. And also it sometimes it causes intolerance. So and it affects the human way of thinking also. So that is the new thing that needs to be really looked into. Uh, the UN Secretary General Antonio Guterres, 2021, he said, and I quote, "Hatred is a danger to everyone, and so fighting it must be a job for everyone." Unquote. So now you find that this United Nations General Assembly, they have passed a resolution on promoting interreligious and intercultural dialogue and tolerance in countering hate speech. And through this resolution, this UN General Assembly, they proclaimed 18th of June as the International Day for Countering Hate Speech, which will be marked for the first time in 2022. So June 18, 2022 will start the first International Day for Countering Hate Speech. It will become the first year when this will be started. And also the United Nations Strategy and Plan Action on Hate Speech. It provides an essential framework for how the organization it can support and complement the state's efforts. And the strategy emphasizes the need to counter hate, hostility, and with full respect for freedom of opinion and expression. Now, coming to liberty, we know the preamble provides the, this liberty of thought expression, belief, faith, and worship. Then Article 21 of the Constitution, it also speaks about right to life and personal liberty. And then we have already Dumar sir, Professor Dumar, he spoke about Shreya Singhal case, which actually deals with this digital era and the freedom of speech and expression, and in the context of Information Technology Act Section 66A. One another aspect of right to liberty is right to privacy. And now this right to privacy is not just relating to right to life and liberty, but also it is related to freedom of speech and expression, also freedom of movement. So, and this right to privacy you will find in United Nations human rights and other international instrument. Also, you will find that they speaks about this human right of right to privacy. Uh, and in India, the first case relating to that, that is the Kharak Singh's case versus State of UP, wherein Supreme Court we have seen that they recognize that this citizens of India they have fundamental right to privacy, and uh, and uh, and the court held that it is a part of right to liberty enshrined in Article 21, as well as right to freedom of speech and expression, and also the right of movement. Then a series of cases were there relating to right to privacy. There is this Justice K.S. Puttaswamy versus Union of India case. Which was decided on 24th August 217. This is Puttaswamy case 1. And it is a historic judgment because it affirms the constitutional right to privacy and wherein it is declared as an integral component of Part 3 of the Constitution of India. Then Supreme Court in various cases also affirmed this right to privacy as fundamental right, be it Navjit Singh Johar versus Union of India case, Puttaswamy 2 case which is relating to Aadhaar Act, uh, which is relating to constitutionality of Aadhaar Act. Then Vinit Kumar's case versus Vinit Kumar versus CBI, and this case is relating to the interception of businessman's telephone calls. And this interception, the court viewed this, Supreme Court viewed this from the lens of infringement of his right to privacy. Not Supreme Court, sorry, the Bombay High Court viewed this as an infringement of his right to privacy. Then another case, the Raut versus State of Odisha, you will find that in this case, the Odisha High Court, it recognized the right to be forgotten. Very important. See, this is a right to be forgotten as a subset of the right to privacy, an integral part of right to privacy. Right to forgotten, like right to privacy is there, and it is very much related to right to privacy. Right to forgotten, you will find that even in US and European Union, this is recognized, right to be forgotten. Now, because when we are in the era of internet, we use internet, so our data is there on the internet, our data is there with the intermediaries who provide us services. So wherever now, whatever services we use, whatever technology we use, our data is stored in that. And once that data is stored, that data remains there. They say that internet does not forget. And therefore, because if some negative news about that person was already there, and the data is already, because the internet already contains that data, the data is retained there, and later on that data could affect the right of the person later on. So this is really in the today's context, this right to be forgotten needs to be this right needs to be actually addressed from the context of the data retention, the data policy, protection policy, because that could affect the right of the person, and that negative news, whatever negative uh, content is there regarding a particular individual or particular thing, then that could affect the further rights of that person. So this is a very landmark thing, and I think that this right to be forgotten needs to be addressed, and needs to be studied from the point of view of the data protection policy. Because the Odisha High Court, it has considered this right to be forgotten as an integral part of right to privacy. Then there is another case, Kush Kalra versus Union of India. This is also in the year 2020. The decision was given by Supreme Court in Kush Kalra case, where this Supreme Court held that pasting posters outside of homes of COVID positive patients, it violates the right to privacy and the right to life with dignity. So we see a number of issues they are coming up because of the technology, because of the changes which is happening in the society, the post-COVID, we can say that many the changes suddenly we find they are happening, and they are giving us more issues to be discussed. So I'll not. I think, yeah. So a lot of time. I will not take much of time. So I will now curtail because the presenters they need to present. So you know that there is a personal data protection bill which is there, and then there are from legislation and policy point of views, there are various guidelines, information technology guidelines, intermediary guidelines of 2011 and 2021, which is relating to the regulation of social media and other intermediaries, and the regulation of OTT platforms and digital news media. There is also the cybersecurity policy of 2013, but it needs to be updated for providing statutory protection for the compromised user. Uh, and there are a number of other acts which control the media, Press Council Act, which decides about the conduct of journalistic conduct, the norms for journalistic conducts. Then there are guidelines for cyber cafe. The rules are there of 2011. Uh, so, like today, now we know that there are a lot of data breaches which are alleged in 2021. It involves Air India, Domino's, Facebook, MobiKwik, etc. And that significantly compromised the personal data of crores of Indian people. And recently, the revelations made by Pegasus project regarding the thousands of possible targets of surveillance across the globe, including India. So these things now um, raises certain questions, that certain issues which India should address. We need a good surveillance framework and a clear data policy, data privacy safeguards, because these are all the challenges which we are facing. Uh, there is also a need to discuss the issue of data retention and right to policy, like in the context of right to be forgotten. Then another issue in the online world is the how to calculate the harm which is being done by the breach of this right to privacy. So all these things, I think, they are required to be looked into, to be debated, to be discussed, to be deliberated in such conferences and others issue. I'll stop here because the time taken almost uh, more time. So I thank you. I thank Principal Professor Dr. Pramod Gilode sir and the organizing team. And I feel like we should let the floor open for the participants so that they can discuss their research paper. Uh, Thank you.
Akash, unmute yourself, Akash. Okay. Thank you, ma'am. Thank you so much for the enlightening insights. And yes, I think you have covered a very vast syllabus, and the papers ahead will help us to discuss this subject in a detail. So I would request you to chair this session, and through this session, we will discuss further on the topic. So. Ma'am, if you permit us, we will really want you to chair the session, and then at the end we will have some more discussion on the topic.
Okay, thank you, Purva.
Okay. Akash,
Yes, ma'am.
yeah, over to you.
Nishita, ma'am, permission. We will start our third session. The question and answer format section will take place end of the session. Okay, ma'am. And now, I heartily welcome to all chairperson and participant in the conference. Now, I firstly invite to Dr. Tenzin Jaganchuk Khampa, ma'am, Professor, School of Law, Pondicherry University, Pondicherry. Ma'am, you present there your paper. Tenzin, ma'am.
I think Professor Tenzin couldn't make it. So we will move further, and we will request Dr. Mukti Jaiswal to present her paper. Yes,
Okay.
Dr. Mukti Jaiswal.
Dr. Mukti Jaiswal, ma'am. I also invite to the paper presentation. She is assistant professor of Institute of Law, Nirma University, Ahmedabad. Ma'am, please.
Yeah, warm greetings to the panel members of the present on the dais, respected Nandita ma'am, the respectable organizers, and the members present over here in this August gathering. The topic for which I had selected for my presentation, topic on which I had written my research paper over here, is the challenges to the laws and regulations related to the online falsehood on social media. This is a paper which has been prepared by me and one of my friend, Dr. Nityanand Pandey, Assistant Professor, IMS Unison University, Dehradun. Uh, so to start with the paper, I would like to start with a basic introduction of the topic of the uh, paper written by me, that the Constitution of India no doubt guarantees the freedom of speech and expression as a fundamental right. This freedom, as we all know, that is not an absolute one. This freedom is not limited to any particular media or any particular platform. With the technological growth, the Supreme Court has also recognized that the freedom of speech and expression is exercisable on all such media platforms, including the online social media platforms too. Social media, as we all know, that are the digital channels created to facilitate the creation and sharing and circulation of the informations, ideas, interest of a person immediately throughout the globe. It is a platform available to available to everyone to express themselves through virtual world and get networked with each other. But emergence of these social media platforms has turned out as both a boon as well as a bane. The various social media platforms have brought the entire world closer, which is no doubt a great revolution regarding the way of communicating together. Physical distance amongst the people is also reduced, and the territorial barriers between the peoples has no recognition nowadays. But as a bane consequences of these social media platforms or these online social media platforms are that they enabled various antisocial elements to spread spread false information or misinformations to create hatred, incite violence, or divide the society, which many a times resulted in social disharmony. These platforms can also be used by the various elements to influence the political thoughts of the people, which is no doubt a great harm to the democratic setup of a country and no doubt weakens the democratic institutions and the processes meant for the proper functioning of the democracy of a country. Thus, it is important to have the appropriate regulations, not only on the paper, but in a practical way also for regulating these social media platforms. But this is no doubt a very complex and challenging task because social media is a platform, online social media is a platform which is accessible by each and every person, irrespective of the knowledge, the IQ, the age of the individual. Since the constitutional protection to freedom of speech and expression extends to social media as well, its regulation shall conform to the constitutional limits envisaged under Article 19, Clause 2 of the Constitution of India. Thus, in this paper, I seek to examine whether the online social media can effectively be regulated, specifically regarding the online falsehood which is circulated through these platforms within the existing constitutional framework and the challenges to it. Continuing with this basic question which I try to examine in this paper, the first analyze the constitutional guarantee of freedom of speech and expression, including the freedom of press and media. The freedom of speech and expression is the most cherished basic human right. The freedom of speech and expression has been accorded the sacrosanct status of fundamental rights in the Indian democracy. The Constitution of India also protects under Article 19(1)(a) freedom of speech and in all forms of expression, whether it will be a verbal communication or a non-verbal communication in a written form or by signs or by visible representation or in any other way. Considering the same concept in year 2020, in the case of Anuradha Bhasin versus Union of India, the Supreme Court has also recognized that the exercise of freedom guaranteed in Article 19(1)(a) is not limited to any particular platform or media. It extends to all the means through which a person can express themselves, including the social media platforms. The emergence of the platform, which is not at all contemplated or imagined by the framers of the Constitution while framing the Constitution of India. Further, it must also be noted that this right guaranteed in Article 19(1)(a) is available to all citizens in equal measures, and it includes the freedom of press, which includes the freedom of press, which includes the expression, expressing a person in any way, that is also includes the modern technological media platforms too. No special privilege is accorded to the freedom of press, as the freedom of press is not expressly guaranteed as a fundamental right in the Constitution of India. It has been impliedly considered as a part and parcel of freedom of speech and expression, and hence all the limitations and restrictions which have been provided to freedom of speech and expression under Article 19, Clause 2 is applicable to the freedom of press and media also. The same has been substantiated through various judicial pronouncements in the numerous cases by the Supreme Court, like Romesh Thapa, as the Nandita ma'am had also quoted, like the case of the Romesh Thapa versus State of Madras, or Brij Bhushan versus State of Delhi, or Express Newspaper Private Limited versus Union of India, the Sakal Newspaper Private Limited versus Union of India, Bennett Coleman case, and so on. So it is quite evident from all these judicial pronouncements that no doubt the freedom of press and media is part and parcel, or incorporated, or understood as a part of the freedom of speech and expression itself, and henceforth it is the limitations and restrictions which has been guaranteed in Article 19, Clause 2 were also applicable on the freedom of press and media also. So it is to understand the constitutional validity of the freedom of press or freedom of media, or particularly the online social media. It is important to understand that the restrictions which has been provided in Article 19, Clause 2. The Article 19, Clause 2, as enacted while framing the Constitution of India, was consist of basically the original constitution. The Article 19, Clause 2 consists of 4 grounds of restrictions: the defamation, including the libel and slander, the contempt of court, the decency and morality, and the security of the state. But later on, 2 amendments has been done in this particular provision, in this particular clause of Article 19. The first in 1951, that is the First Amendment Act, and the second amendment was done in through the Constitutional 16th Amendment Act in 1963. Through these 2 amendments, the first major change which has been brought in Article 19, Clause 2 is the enhancement in the grounds of restrictions. Now, the present clause have approximately 8 to 9 grounds of restrictions on or limitations on the basis of which freedom of speech and expressions can be restricted or curtailed. And the second important amendment, or which has been brought in this Clause 2 through the First Amendment Act, was the addition of the word reasonable before the word restrictions in the provision. Through these changes in the Article 19, Clause 2, it can be concluded, these 2 amendments in Article 19, Clause 2, it can be concluded that the state seems it seems it important to enhance the grounds of restrictions for appropriately regulating the freedom of speech and expression, along with the freedom of press and media, for the purpose of assuring the objective of for the purpose of protecting the democracy of the country. But along with this, considering the basic purpose of the basic objective of the Constituent Assembly, the word reasonable has also been added before the word restriction, that no doubt by enhancing the grounds of restrictions, the freedom of fundamental right of freedom of speech and expression no doubt curtailed very much, or can be curtailed very much, but it can be done only on the basis of reasonableness, on the basis of fairness. So these two amendments has no doubt tried to maintain a balance while guaranteeing the freedom of speech and expression, including the freedom of press and media, in a balanced way that the democratic setup can be prevented, as well as the basic purpose of the Constituent Assembly or the vision of the Constituent Assembly cannot be hampered. So in this way, no doubt the freedom of press and media can be considered, or the constitutional validity of the freedom of press and media can be considered, can be determined, that this freedom is not provided in the absolute form, but it has been guaranteed in such a way with the reasonable restrictions so that the democracy cannot be hampered, the basic ideologies and the basic structure of our country cannot be uh, will not be in danger. Coming to the regulations and the laws which has been framed regarding the online falsehood in the age of social media, the information and communication technology, which is the defining feature of the contemporary age, has redefined the way people interact and the speed with which they communicate with each other is no doubt a great one which cannot be before, which was not there before. Distances among the people in now present world is not matters at all, as we can evident right now that we are all part of this international conference right now, but sitting at our own places, but still we are interacting with each other and discussing such a important topic, relevant topic over here. So this clearly evident my submission that the distances is not at all matters in present world. The internet and social media platforms have provided greater opportunities for the people to pass on news or information and more publicly and openly express their views, ideas, opinions, beliefs, etc. With internet enabled hand handles like mobile phones, iPads, one can make videos and share it with others on various social media platforms within seconds. These innovations and developments in the form of social media platforms might be described as anti-social media platforms too, as these platforms can even be misused by the various persons, various anti-social elements, as I mentioned at the starting of my presentation itself. Having regard to its negative potentials, which could have far-reaching consequences, the legal regulations has become imperative. World over, increasingly the needs in felt to regulate social media platforms, and some countries, specifically I would like to mention Singapore over here, lead and enacted a statute named as Protection from Online Falsehood and Manipulation Act 2019. I would like to specifically mention the section 7 of this act over here, as section 7 of this act not only section 7 of the said act criminalize the communication of false statements or false facts through the online social media platforms, and the punishment has been imposed through this particular statute, through this particular enactment, for spreading the online falsehood statements on the social media platforms, which may incite the feelings of enmity or hatred among the people, or which will hamper or harm the friendly relations of the country with the foreign countries, or the international relations of the country, or diminish the confidence of the people in the government system or the democratic governing system of the country, or influencing the election process of the authorities over there. Any kind of such false statements, publication of any kind of such false statements over the online social media platforms has been considered as a criminal offense in the said act, and accordingly a heavy punishment and penalty will be imposed. Similarly, considering the Indian scenario, no doubt in India also we are having certain regulations to deal with such kind of matters, like we are having the section 153, section 499 with 500, section 5051 of the Indian Penal Code 1860. We are having section 66D of the Information Technology Act 2008, or section 54 of the Disaster Management Act 2005. But what is needed to be considered over here is, even though we are having these several enactments, regulations, the statutory provisions for regulating the spread of online false statements, but still when it comes to the practical application of these provisions, it is very challenging to deal with such kind of matters or to make these laws practically enforceable, because of the access of the people to these platforms is very easy. So it is needed that it is a need of an hour that the government has to think not only for enacting the appropriate rules and regulations regarding these regarding the use of these online social media platforms, but they have to take the appropriate adopt the appropriate practical measures, implementing measures for the for achieving the basic purpose of enacting these laws, rules and regulations. It is the need of an hour to strike a harmonized, balanced between the assurance of the fundamental freedoms to the individual, as well as the practical enjoyment of these fundamental freedoms by the individual. This is a basic challenge before the authorities nowadays, which can be resolved, or which can be met out only by making the adopting the proper implementary or enforceable measures by the government. Because as when it comes to the enactment of laws, we are having ample amount of laws for regulating the such kind of social media platforms, but when it comes to practical application, we need the appropriate guidelines to meet all such spread of online false statements on the social media platforms. This is all about my presentation for the today's conference. Thank you, everyone.
Thank you, Mukti.
Thank you, ma'am.
Professor.
Actually, I also requested Professor Praful Telugude sir. Praful Telugude sir.
Hello, Akash.
Yes, ma'am.
Okay. Thank you, ma'am. Thank you, Mukti ma'am. I think Akash is having some issue with his mic. Is he audible to you?
Hello, ma'am.
Was audible?
Yes,
it's
Akash.
audible.
Hello. Can you hear me, ma'am?
Yes, Akash. Yeah.
Yes, yes. Okay, ma'am. Please, I also invite the Anand Chakranarayan sir, Dr. Ambedkar College of Law, Aurangabad. Sir, you can join the conference and present your
Yes,
paper,
yes.
research paper.
Am I audible?
Yes.
You are audible.
Sir, yes.
Yes, sir. Yes.
Ma'am, there is a network issue. That's why I am unable to switch on camera.
Yeah, that would be fine, Anand.
Yes, yes, yes. Thank you, Dr. Babasaheb Ambedkar College of Law, Naksin, Aurangabad. Principal Dr. Pramod Herode sir, Assistant Professor Dr. Purva Karthik madam, and all college staff. My name is Anand Divakar Chakran Narayan. I am student of NLC 4th, Dr. Ambedkar College of Law, Naxinun, Aurangabad. My research paper title is Freedom of Speech and Expression in the Age of Social Media. I will start my paper. Introduction. Every person have natural right to express his thoughts, freedom of speech without fear of any pressure. Also, every person have right to enjoy his liberty. This right gives us to every person by our constitution. In this topic, we discuss about freedom of speech and expression in the age of social media. Firstly, we focus on social media. What is social media? Social media comprises primarily internet and mobile phone based tool for sharing and discussing information. It blends technology, telecommunication, and social interaction and provides a platform to communicate through words, pictures, films, and music, also videos. Social media includes web-based and mobile technologies used to turn communication into interactive dialogue. In social media, there is so many apps were running. That is Facebook, WhatsApp, Twitter, Instagram, YouTube, LinkedIn, Orkut, etc. They were connected to each other via internet. It is a telecommunication, that is data telecommunication. Within a nanosecond, the information is spread up in worldwide. Where the information is good or bad, true or false, right or wrong. It can be justified by viewers and readers. Now, last past years, very false and most irrelevant information was passed through the various social media platforms, and this false information was produced violation of the right of speech and expression. But nowadays, social media is a weapon of every person's hand to utilize or express their speech and expressions by the media of voiceless as well as voicely. Social media is a powerful platform to transform our democratic right into written or verbal communication in the society. How we use social media, it is a very important thing. If we deliver falsy or malicious statement via this platform, it is not useful for for ourselves as well as our society and as well as our country. But we spread our good motivational, impressional as well as legal perspective thoughts through this social media. We achieve good vibrations from society, and it is positive sign to propagate good moral thoughts in our society. Freedom of speech and expressions. Freedom of speech and expression is broadly understood as a notion that every person has the natural right to freely express themselves through any media and frontier without outside interference, such as censorship, and without fear of a reprisal, such as threats and persecutions. Freedom of expression is a complex right. This is because freedom of expression is not absolute and carries with its special duties and responsibilities. There, there it may be subject to certain restrictions provided by law. Everyone has a right to freedom of opinion and expression. This right includes freedom to hold opinions without interference and to seek, receive, and impart information and ideas through any media and regardless of frontiers. Article 19A, subclause 1 of the Constitution provides freedom of speech and expression, which is the right to express one opinion freely without any coercion, threats, and fear through oral, written, electronic broadcasting, and through press, that is print media. In drafting committee, there was a debate on this article that freedom of press is not mentioned in the article, and hence it is a serious lapse of drafting committee. But Dr. Ambedkar, while replying to this concept, and said that press has no special right which are not to given to an individual or a citizen. Dr. Ambedkar further said that the editor or a manager of a press are all citizens of the country, and when they choose to write in newspaper, they merely express their views as a right of expression. Hence, right of expression includes right of press. As mentioned earlier, Article 19 1A of the Constitution of India also confers on the citizens of India the right to freedom of speech and expression. The freedom of speech and expression means the right to express one's convictions and opinions freely by word of mouth, writing, printing, picture, or any other mode. It is also include the right to propagate or publish the views of the other people. The term freedom of speech and expression includes any act of seeing, receiving, and imparting information or ideas regardless of a medium used. Based on John Milton's argument, freedom of speech is understood as a multifaceted right, including not only the right to express or disseminate information and ideas, but also including the right to seek, receive, and impart information and ideas. Freedom of speech and expression and social media and also internet. The internet and the social media has become a vital communication tool through which individuals can exercise the right of a freedom of expression and exchange information and ideas. In the past year or so, a growing movement of people around the world has been witnessed who are advocating for change, justice, equality, accountability of the powerful and respect of human rights. In such movement, the internet and social media has often played a key role by enabling people to connect and exchange information instantly and by creating a sense of solidarity. The United Nations Human Rights Committee has also tried to give practical application to freedom of opinion and expression in the radically altered media landscape, the center stage of which is occupied by the internet and mobile communication, describing new media as a global network to exchange ideas and opinion that does not necessarily rely on the traditional mass media. The committee stated that the state should take all necessary steps to foster the independence of these new media and also ensure access to them. Moreover, Article 19.1 of the UDHR and Article 19.2 of the ICCPR also provides the freedom of speech and expression even in the case of internet and social media. Thus, it's seen that freedom of speech and expression is recognized as a fundamental right in whatever medium is exercised under the Constitution of India and other international documents. And it at, and in the light of the growing use of internet and social media as a medium of exercising this right, access to this medium has also been recognized as a fundamental human right. The freedom of speech and expression does not confer on the citizens the right to speak or publish without responsibility. It is not an unbridled license given immunity for every possible use of a language and prevents punishment for those who abuse this freedom. Article 19.3 of the International Covenant of Civil Rights and Political Rights ICCPR imposes restriction on the following grounds. First is for respect the rights of reputation of others, for protection of a national security or public order or public health or morals. As per Article 19.2 of the Constitution of India, the legislature may enact law to impose the restriction on the right to speech and expression on the following grounds. That is, first is sovereignty and integrity of India. Second is security of a state. Third is friendly relation with foreign state. Fourth is public order. Fifth is decency or morality. Fifth is contempt of court. Sixth is defamation. And seventh is incitement to an offense. Lastly, my conclusion is it is clearly evident that social media is a very powerful means of exercising one's freedom of speech and expression. However, it is also been increasingly used for illegal acts, which has given force to the government attempts at censoring social media. Where on the other hand, the misuse of a social media entails the need for legal censorship. There are legitimate fears of a violation of a civil right of a people and inevitable consequence of censorship. The references is Article 19.1a Constitution of India 2018, 10th edition, page number 16, 17, 18. Article of Rohit Rajji defining contours of press freedom in a backdrop of a national emergency of 1975. All India Reporter, 2008, page number 155-160. Freedom of expression everywhere article available on www.oschr.org, and Article 19 Universal Declaration of Human Rights 1948, Article 1991 and 2 International Covenant of Civil and Political Rights 1976 ICCPR. Thanks, madam.
Thank you.
Thank you, Anand Chakranayan, sir. Thank you, Anand Chakranayan, sir. And
Okay.
lastly,
Thank
I
you.
also invite the Professor Praful Telugude, sir. He was also working assistant professor, Dr. Ambedkar College of Law, Aurangabad. Sir, you have present your research paper. Praful Telugude, sir.
Thank you, Akash. Good afternoon to all of you. I will present my paper, Right to Privacy. The right to privacy implicit the sense allow each individual is a sovereign, and he recognized that right of privacy is individual right, free speech, assembly, and expression. It is also said that Ruscobon, in his philosophy, right of privacy is a part of the fundamental right of individual. The nature of right to privacy is unalienable right. Right of privacy means right of individual to exercise control over his own body or personality. Right of privacy is a natural right, inalienable right. It is inseparable from human personality. John Locke propounded in his philosophy, that is social contract, life, liberty, estate are the fundamental rights. John Durkin asserted man has fundamental right against the government in his strong sense, like free speech, if the right is necessary to protect his dignity or standing as equally entitled to common and respect or some other personal value of like consequences. Evolution of right to privacy in India. That is first time right to privacy.
I think there's a technical issue with Professor Telugude's connection.
Also right. Prisoner has right, but prisoner has curtailing right concerning about by procedure established by law, but prisoner has not left all right, but he has certain right, but he can preserve his liberties by preserving his some of the right. He has not lost his all the right, that is all liberty, but some of the rights is having him till. Okay, the next is the preamble of the Constitution of India is also containing about the liberty. In Keshwananda Bharati versus State of Kerala, Supreme Court held that the Constitution of India, okay, It speaks securing the liberty of thought, expression, belief, faith, and worship. That idea of individual justice, liberty, and equality. The Constitution of India guaranteed the indispensable right of liberty. In Keshavananda Bharti versus State of Kerala. And Supreme Court overruling the ADM Jabalpurwala versus Shukan Shukla. It was held that ADM Jabalpurwala Shukan Shukla held that the right to life and personal liberty is unalienable right, cannot be separated or suspended of human personality. In international scenario, right, personal liberty is also recognized in UK Constitution. Procedure established by law. In Mithu versus State of Punjab and Bachchan Singh versus State of Punjab, Supreme Court held that liberty can be curtailed by a procedure established by law in India, essential for the privacy. That is, essential nature of the privacy, inseparable right from the personality. In relation to the informational privacy, in Supreme Court held that the purpose of privacy is in Puttaswamy case, that is if we requiring the information from the person, we must give a notice. That is, before collecting a data, that we must inform to the person from whom we have to collect the information. For what we require that information, we must give prior notice to that person while we are collecting the data. That we must have give a choice. That is consent. While collecting the data, we must have to obtain the consent of that person, particular person, whose data we are collecting. And collection should be limited. While we collecting the data or information of the particular person, we should have given the information that we are requiring particular data and we are collecting your data, but in very limited aspects. Purpose should be clear. You have to mention while you are collecting the information or data of person, you have to particularly mention for what purpose we are collecting the data. Access and correction. That we are collecting the data, we must have to give a correction correction purpose or information concerning about the particular data. That disclosure of information, that it is also required while we are getting the information, we are collecting the information, that is we are collecting the personal liberty or collecting the personal information of the person, that we must have to disclose that for what we have to collect the information, that we must have to maintain the secrecy or security while we are collecting the information. We should have to give secrecy, ensure the secrecy of information, and it should be in openness. While we collecting the information, it should require openness of the information and accountability. That we are collecting the information, we are accountable for that particular information. If in case of it is hacked or in case of it is lost or damaged, we must have to accountable for that particular information. That in KC Puttaswamy versus Union of India, there are various separate judgment delivered by various honorable Supreme Court judges. That one of the honorable Supreme Court judge, that is Chelemishwar, he stated that extended the liberty under Article 19 to the non-citizen. He held that the people have right to freedom of choice, their dress, appearance, such as keeping hairs, wearing turban, political or religious belief. It is integral part of the privacy. It includes right to keep braid and right to wear hijab. He agreed with the other judges. That is another Supreme Court judge held its opinion separate judgment by in K.C. Puttaswamy. He gave separate judgment, that is right of privacy is both common law right or fundamental right. That is S.A. Bobde. Then another honorable Supreme Court judge F.R. Fali that he opened that the personal liberty means the liberty of person from external restriction or coercion. He agreed with the other human law right. It is inseparable from the human personality. Another judge was Justice Separate. He stated that the judgment that privacy is implied in Article 19, Clause 1A2. Unity and integrity of nation is impossible without privacy. And another judge, S.K. called right of privacy is fundamental right guaranteed under Part 3rd of the Constitution of India. Now I am concluding my paper. Every person have right to marry, sex, choice, that is control on his own personality by his own will. All important aspects of human dignity are protected in privacy. Okay, thank you for organizing committee. Thank you for all those are participating, and thank you for all hearing to me patiently. Okay.
Thank you, Mr. Devwood.
Thank you, sir. I inform to all, we are nearly end of the session. Whenever Honorable Chairperson Nandita ma'am, with your permission, I request to you all participants, who's anyone interested, any question?
Right. Like the session, we can say that it is open for question and answers. You can ask the question to the participants, those who have presented their paper. The participants can put questions to the presenters. The session is open for question and answer session.
Anyone interested? Any question? Some queries?
You can also share your observations if there are no questions.
Ma'am,
Okay,
I
ma'am.
think there are no questions. So I would request you to comment on the papers and to move for the discussion, like what the presenters did and what is your observation on this theme. So over to you, ma'am.
Thank you, Guru. Yeah, so total of 3 papers they were presented and they were from varied topics. Yeah, first of all, I congratulate all the 3 paper presenters for their wonderful presentation and for giving us new insights on the different topics relating to privacy, online challenges and online falsehood issues, and social media perspective. Uh, the first paper presented by Professor Dr. Mukti Jaiswal. Um, Professor Jaiswal, I really appreciate the the topic that you have taken for your paper. Um, because in this era now, we need to look into the new things, new issues which are there and which need to be uh, taken care of. You have spoken about the challenges relating to that online falsehood, and a very nice way you have like you have discussed about the right which is enshrined in the Constitution relating to freedom of expression, speech and expression, and uh, regarding the regulation, I must say the Singapore Act, which you mentioned, especially the Section 7, uh, that is a that will really help the policymakers to think on it. It's the presentation is very nice, and uh, the way you have discussed the topic very nicely. You have done that. Uh, Online falsehood. I feel like on this concept. I think if you can elaborate more, that would help the readers to uh, know about the varied types of online falsehood are there, and how like the challenges are there, regulatory challenges would be there. Uh, but rest of the thing, I think that your paper is very good and uh, should go for publication in the paper. Mm. Second participant, Anand Chakranarayan, was a student, an LC4 student. Uh, his topic was on freedom of speech and expression in the era of social media. He has discussed the constitutional provisions in this era of social media. In his paper, I would like, because he is speaking of social media, so I would suggest him this is like he could also bring into his paper IPR perspective, the intellectual property, because in social media, uh, most of the thing there are there's a lot of violation of copyrighted materials, and various types of IP property is like protection issues involved. He can also elaborate his paper by discussing on the various case laws which are related to the social media, the issues or the disputes relating to social media. So landmark cases he can add in his paper, uh, and that will be like a jurisprudential aspect you could bring in. Uh, that would be good if he can do that, so that he can also go ahead with the publication of his paper. Uh, the third paper presented by Professor Delgote regarding right to privacy. Actually, I'm very sorry I couldn't get most of the part of your paper because of the technical glitches in between. There was the voice issue was there. I couldn't hear the voice. Then there was echoing, and in between there was pause. So I got this. In parts, I could understand what he is discussed in this topic. So I will not be able to properly give my observation on his paper because of the technical glitches. This is the side effect of like this technical things, because certain things are good, but certain things are we need to bear with it. So I'm very sorry, but only the thing that The title, I think, because Indian perspective you discuss, I hope, because in between whatever I heard, there is about the Indian perspective. So you can reframe the title in that. Regarding other things, I think if I will read the paper, I will be in a better position to express my observation, express my views. Thank you. And once again, I congratulate all the three paper presenters for their presentation. And I wish you all the three publish your paper, get your paper published. Thank you. And thank you all the participants for their patient hearing and be a part of this session, and the organizing team for uh, giving this opportunity to me to share this session.
Thank you so much, ma'am. Now, with your permission, I hereby declare end of the session. And next session
Yeah.
of valedictory, I invite to Honorable Professor Sri Kishan N. More sir. He was completed his BSc, LLM, NET, MA Thoughts, and he was presently working in Associate Professor and Vice Principal of MP Law College, Aurangabad. So, I invite to Professor Sri Kishan More sir. More sir, can you hear by me?
Yes, sir. You're audible. Hello. Can- yes. Can you people hear me? I think today, when we are talking about the social media and the internet world, where we are talking about the freedom of speech and expression, so I think this is a good place where we are facing a lot of difficulties. That in the era of internet, how our freedom to talk and our freedom to discuss can be hampered by the technology. So that is really interesting. So I am awaiting. For response from the Professor More sir. So meanwhile, if any one of you have any question, any observation, or any comment, please type it in a chat box, or you can raise your hand, or you can speak. I think we are unable to reach him. We will try once again. Okay. And sorry for the inconvenience. I will try to reach to him again.
सर मोरे सर तुमचा माईक ऑन करा.
Okay. Maurice sir is trying to join us as soon as possible. Meanwhile, I think there are lots of comments in the chat box regarding the conference. Okay. So any one of you want to comment, okay, regarding the whole conference or the whole process, or even on a particular presentation, you are welcome to do that.
Thanks.
I think, yeah, we need some more time. Meanwhile, I'll request our principal, Professor Pramod Hirvade, to comment or give his observations on today's conference. Over to you, sir. I think, yes, I think Morisa is also here. Uh, uh, yes, Morisa, can you hear me? So please unmute yourself. Yes, sir. Over to you, sir. Yes. Morisa, you are not audible. Could you reconnect your mic? Okay. I will request Professor Pramod Hirvare uh, to comment on the conference, and meanwhile, if we will see if Professor More can join us. Okay. Yes. Over to you, sir.
I'm really thankful to you all for showing in our one-day international conference. Friends, the issue which we have dealt is of great significance for multiple reasons. Because it is a high time to revisit the concept of liberty, the concept of freedom of speech and expression in the given situation. In addition to this, I also really thankful to Professor Cardio who has joined this conference from Mexico and did justice to the topic by delivering his quite informative speech on this. Again, really thankful to Professor Nandita Patil that she, on such a short notice, shown her positive response and participated the seminar and delivered a very informative speech. That for the first time, I came to know that it was Dr. Baba Saheb Ambedkar who has endeavored to bring about the concept of liberty and sow the seed on the Indian society of liberty by way of annihilation of caste and everything. So with this, I really express deep sense of gratitude to you all participants, students, researchers, advocates, academicians, and so forth. So with this, I conclude and ask to the host to please continue.
Uh, Thank you, sir. Thank you so much. Now, I would request Dr. Gatha Neraligar to give vote of thanks.
Thank you, ma'am. Good afternoon, all. Thank you is such a prayer that cannot be seen or touched. It must felt by heart. I, Dr. Gatha Nirlikar, Assistant Professor, Ambedkar College of Law, feel honored to propose a vote of thanks on this special occasion. This is a momentous day in the history of our college as we have for the first time hosted the international conference. I would like to thank all the honorable guests and chairperson, Dr. Ramratan sir, Dr. Nandita ma'am, who blessed us with their presence and their valuable guidance. I would also like to thank all the participants from different parts. An event of this dimension cannot happen overnight. The wheels started rolling months in advance. I want to extend a vote of thanks to our respected principal, Dr. Pramod Herode sir, for his constant guidance and support to shape the conference. Last but not least, I would like to thank to our organizing team and our respected teachers for making this event a successful one. I hope we continue to work like this and organize such events in the future for the betterment and upliftment of our students. Thank you all. Have a wonderful time. Over to you, ma'am.
Thank you all. Thank you so much. and hope that in future we will meet in person and we will discuss more issues. So on that note, I am going to end this meeting. So thank you everyone, and see you when we see you. Thank you. Bye.
Thank you. Thank you everyone.